Please welcome, big round of applause, Rob Maher.
Well, good morning, everyone, and thank you, Cole, for that very kind introduction. Again, for those of you who I've not yet met, I teach electrical engineering at Montana State, so I teach courses in transistor electronics and circuit analysis and digital signal processing and all the things that go into the curriculum there. And then also on my research side, and then on some of the courses I teach have to do with audio engineering, and for the last 15 years or so, primarily audio forensic analysis. So again, I'm very pleased to be invited here. The other aspect of the remarks that I wanted to make have to do with looking at the history of this conference, which is now just about 20 years old. The first meeting of Audio Engineering Society Audio Forensics Conference was 2005, and I'll mention a few things about that. And so in preparing this talk about the future, I think there's also kind of a need to see what the vector is, meaning where did we start, how are things moving forward. So I'll share a few remarks and viewpoints on that, and hopefully if I manage my time well, there'll be some opportunity for rebuttal, questions, comments, and so forth. And that, of course, is the great thing about a conference like this, is that I hope we have some time to interact and not just hear lectures and so forth. So that's kind of the framework there. So I've been an AES member since, I think, 1985. So that's going on 40 years. I used to have dark-colored hair, and apparently I've been in Montana now for 20 years, and they must put something in the water there because my hair was never gray until recently. So interesting how time goes by. But we'll see how that works out. So where are we looking forward to, and where have we been in audio forensics? So after this little bit of welcome, I want to give a little bit of framework on some history of audio forensic analysis and some of the constraints and opportunities that we have in the field. There are some things that used to be very important in the field, like analog magnetic tape, that are probably less important now, but we can talk about that. And then we have some new challenges and opportunities that have come out, particularly with the rapid advent of artificial intelligence topics, and of course we'll have papers at the conference about that. I also want to say a little bit about what I think are some of our call to action, or the things that our profession can do to help keep us relevant and to help make our role in the criminal justice system in particular more useful and more significant. And my viewpoint comes primarily being here in the United States from the U.S. framework, and again, I hope there'll be an opportunity for those of you that are in South America, Europe, Australia, around the world, to maybe say a few things about the context in your jurisdiction, because that is important for all of us to know and learn from. So thinking about the U.S. history, there certainly were considerations of audio or sound or acoustic analysis that date back even into the 1800s, probably the 1700s. But as far as recordings and electronic means, which is more where I'm kind of starting here, I think probably the first area that we noticed some development was in terms of wiretaps. So telephones had started becoming available in the late 1800s and into the 20th century. And in the United States in 1934, the Congress passed the Communications Act, which had very profound changes to many things about radio communications and telecommunications in this country. And one of the things that was in that law were some comments about wiretaps. So the idea that somebody could listen in or eavesdrop on an electronic conversation. The interesting thing about it at that time was that it was felt on grounds of the Fourth Amendment, protections against unlawful searches and seizures, and Fifth Amendment, which in the U.S. that means the prohibition against self-incrimination. So people could not be required to testify against themselves. And the question was, well, if you've recorded a phone call, maybe that person's testimony now is in electronic form, and that was pretty much outlawed. Now, there were some details, as usual, in the language that the Congress passed on that, which had to do with whether it was possible to listen in and then not publicly disclose the conversation. So, for instance, an investigator could listen and use the information, but then couldn't divulge that in court or something like that. But anyway, that was pretty much ruled out, that kind of combination. But after World War II and into the 1950s, it very quickly became possible to make audio recordings that didn't require a recording studio or hooking up to the telephone lines. You had a portable magnetic tape recorder that could be used. And so now a lot of the initial constraints that were considered were no longer really there. And so although the Telecommunications Act prohibited wiretaps, what about surveillance recordings or surreptitious recordings of conversations? Was that okay? And now the question came, well, what about the authenticity of those recordings? Even in those days, there was some concern that voice actors might be recording, or there might be editing and things like that happening. And then the quality of these recordings became very important. So most of us who work in audio forensics now are usually called in cases where it's not obvious what's being said because the recording is of terrible quality. And so now we have to deal with all the issues that come up in those kind of cases. So all of these things, went back from the 1950s. In 1968 in the U.S., another bill was passed that did permit wiretaps to take place, but in that case, in order to deal with the Fourth Amendment concern, a court order was required in order for that to happen. And so that's the current issue, at least in most of the United States, that we're still operating in. So again, looking a little bit at the history here to kind of set up, well, where are we headed and where are we going? I wanted to mention in particular the case known as McKeever, which is one of the cases that is often brought up in talks like this as one of the initial points in which audio forensic concerns were dealt with in the U.S. court system. So in this case, Thomas McKeever and Lawrence Morrison were indicted for racketeering. They were members of the Longshoremen's Union and at the time kind of notorious for strong-arming various businesses to get their union needs met and so forth. And these two guys got indicted. After the indictment, McKeever knew that one of the likely witnesses who was going to testify in the subsequent case was named George Ball, a business owner. And so McKeever arranged, and I don't quite understand the circumstances, but he arranged to secretly record a conversation with George Ball. So he got Ball to come in, and they had a conversation and said various things, and then that got recorded. Now, during the trial, in the cross-examination of George Ball, the defense of McKeever had this tape. Okay? So they wanted to impeach Ball's testimony by saying, hey, we got a tape of you saying this other thing that's different than what you just testified, and then that would, of course, impeach his credibility. At the time, George Ball on the stand said, well, I don't remember that conversation. I don't recall that. And so the defense got permission from the judge to play through headphones this recording that they had made to refresh George Ball's memory about the conversation. So they didn't play it so that the jury could hear it or anything, and there was no transcript. They just let the witness, George Ball, hear it. So Ball then said, hey, yeah, I do now remember this conversation, but he subsequently said, yeah, I recognize McKeever's voice and McKeever's brother's voice, but I don't recognize my own voice in this recording. So he sort of denied that it was there, and he said it doesn't matter because basically what I said in the recording is the same as my testimony. Okay. So the defense then said, well, this is not true. We want to play this tape so the jury can hear what this guy said and prove, in their viewpoint, that what he said now was different. So the question then came up, should the court allow the jury to hear this tape? And the prosecution then argued that they should not because they had not established the authenticity of this recording, its accuracy, the circumstances, who the talkers in the recording were, or anything else. Okay. So that's what the court had to deal with. So on appeal then, appellate court came up with the following list of what we often call the McKeever tenets of audio authenticity, which were the list of 7 things that needed to be shown in order to establish that a recording could be admitted as evidence. Several of these, by today's standards, we probably don't really think about too much, that the operator of the device was competent to operate it. Perhaps in the 50s there was some issue about the mechanics of operating a recording device. Nowadays, everybody's able to make a recording, so probably that isn't quite a big thing. But item 3, that the recording is authentic and correct, still comes up today and is still a great concern in introducing audio evidence in United States courts. Number 4, that changes, additions, or deletions have not been made in the recording is also a concern even today. So these things that were true back in the 50s are still there. And we have 6, that speakers are identified, and 7, the conversation was elicited voluntarily and in good faith. So even today when audio evidence, in this case dialogue evidence, is to be introduced, typically these are the standards that are still used in U.S. courts to try to establish is this true or not. And often there's a dispute, and many of you may be involved in this, the dispute about the authenticity or the identity of the talkers in the recording. So ultimately, the court was saying then that they could see, this is 1958, advances in technology and electronics will make it inevitable their increased use will happen in court. So they could even see at that time that there was going to be more and more of this. And I think now with everybody walking around with a recording device on them and every doorbell having a recorder and every police officer carrying a body camera and so forth, we're certainly seeing the implications of this. Okay, so again, historically and into the future, we're seeing kind of a continuity in some of the concerns that we have here, and the framework is different today, but it's still there. Okay. Another topic that kind of comes out of history was shortly after the McKeever case, we had a lot of interest in using technology for various kinds of forensic purposes, and one of these was developing what were known at the time as voice prints. So Lawrence Kirsta, who was at Bell Telephone Laboratories at that time and later started a company to deal with these types of things, made an assertion that it would be possible to essentially take a spectrogram of a person's voice and use that as a way to identify that person. This topic came up at our first, I believe it was our first, Durand, 2005, was that your paper on this topic of voice print analysis? We're also faced with the fact at that time where fingerprints were thought to be this perfect J. Edgar Hoover way of determining identity of people, and I think now we're starting to see some concern about whether those things are as reliable, and certainly the use of voice print identification and identifying people based on the spectral analysis of their speech is still a controversial topic. And we'll hear some papers at this conference talking about that, and hopefully we'll have some clarity and understanding about how these things work. But even the National Research Council panel who was asked to look into this basically punted. Okay. So they said, we don't really know if this is possible or not. We don't have a scientific way of determining it. So let's just make sure that experts like us, if we're testifying, are being thorough to explain to the jury and the judge what the nature of this evidence is and what the uncertainties associated with it are. Okay. And so again, something from history that I think we're still going to see as we move forward, and perhaps an increased basis as we start having more and more audio evidence available and more tools that might be used to ascertain what's going on with these types of things. Another historical topic that's often brought up in history talks about audio forensics is the Watergate tapes. And I, for one, am old enough to actually remember when this was going on, and I was fascinated by it before I knew what it meant to be an engineer. But at the time, I thought, boy, this is pretty interesting. So the Watergate refers to this break-in at the offices of the Democratic National Committee at the Watergate office complex along the Potomac River in Washington, D.C., 1972. After this break-in had turned up, there was a lot of investigation about who had done it and who the people were, and a lot of questions came up. And among the things that happened during a congressional investigation into this was that White House aide, Alexander Butterfield, revealed to a stunned audience that President Richard Nixon had arranged to have recordings made in the White House and the Executive Office Building and at Camp David of all of his meetings. So you can imagine when people are wondering, well, what was going on in these discussions, when they find out that there are recordings of everything, that's real interesting concept. Now, I should say that not only had Nixon done these recordings, but prior to him, Lyndon Johnson, President Johnson, and even President Kennedy, the prior presidents, had also done some selective recording, but not to the extent that Nixon had done this. I believe Nixon, what he was thinking was he was going to then, after he was out of office, use these tapes to prepare a memoir or something like that. So it was more for his own personal use, not for criminal investigation. Eventually, the courts told the president he had to release these tapes. They first had prepared transcripts, and then they said, no, we have to get the real tapes. And one tape, which was just 3 days after the Watergate break-in had taken place in 1972, curiously had an 18-and-a-half-minute gap in the recording, so that you can hear the voices, and suddenly there's a noise gap that's presented. And of course, the question was, well, what happened? Did the recording system malfunction? Or did somebody later go in and say, oh boy, there's some incriminating stuff in here, we need to erase it? So authenticity immediately became of interest. So the judge, U.S. federal court judge, John Sirica, decided that there needed to be an investigation of this, and it probably wasn't going to be attorneys that were going to be able to do that. So he got the attorneys to get together and come up with a list of names of experts who they could agree on who would examine this tape recording to try to figure out what happened. All of these individuals have now passed away, but they are names that if you work in audio engineering or audio engineering society, many of them are quite familiar. So it was a good list of people who were qualified to look into this. They did a lot of work looking at the signals that came out of the tape and things like that to try to see, was there a way to reconstruct any of the speech that took place in that, but I think very quickly they determined that it had been erased. There was nothing legible on the tape anymore. And Jay McKnight, AES member, who had worked with this use of magnetic development, which was a way to observe the latent magnetic patterns on magnetic tape, is the one who pretty much came forward and was able to identify various markings on the tape that were due to the record and erase head of particular types of tape recorders. So again, you have to go to the Smithsonian or something and see tape recorders, but in any case, there was, when you had an analog tape and the magnetization started up, it left a particular signature on the tape, and those were identified. And in fact, the report that they produced showed the various segments and where these start-stop erasures had occurred. And what's more, they were able to figure out which tape recorder likely made those erasures. And it was in the White House, not the same recorder that had made the original recording, but at some other time. And so, again, there's a lot of intrigue about how this actually occurred, but a very important step in the acceptance of audio forensic analysis in this investigation. Then there have been other historic cases since then. I think one of them after the Watergate era, there was a lot of suspicion about government use of various evidence, and one of the things that was looked at again were the John F. Kennedy assassination in Dallas many years earlier. There were purportedly various recordings, audio recordings that might have contained information about that. There were reconstructions of audio evidence with actual gunfire in Dealey Plaza to try to examine what happened. And many of the results of that have now been kind of debunked, but at the time there was a lot of interest in audio forensics for that. Another example, after 9/11, there were various audio recordings purportedly of Osama bin Laden made, and one of the questions had been, well, maybe bin Laden had been killed earlier, and so if a tape recording appeared, the question was, well, is that contemporary, or was that from before, or is it not even him? And so there was a lot of interest in trying to understand that. The notorious murder situation with Trayvon Martin and George Zimmerman in Florida, there was also audio recordings available of that were ultimately not used in court for a variety of reasons, but there was evidence presented on that, and there's many more. Hopefully some of you will think of some that you're familiar with, maybe not even in the United States, that have used these audio forensic techniques. All right, let's move on to part 2. What has AES been doing, the Audio Engineering Society? How have we been involved in this? Well, we've seen a few AES members who have participated in some of these investigations, but probably the big thing that we've done is gotten together in meetings like this. So there have been 7 prior AES international conferences held, and for each of those, I was asked to write the convention report. So I've been busy looking at those old reports about all of these meetings. AES doesn't seem to do that anymore, unfortunately, but it's been fun to have those accounts of those prior meetings, and I do invite you to look back. They're on the AES website. You can find them. But the first one was in July 2005 here in Denver. Was it at this hotel?
Yeah. Yes.
Okay, so we've almost 20 years have come back to where we started, and that's really, really something. So we've met here in Denver many times. We've also met, Eddie hosted us in Denmark. We were in London, had a very good meeting there a few years back. Arlington, Virginia. I think we've seen some of the people that organize these conventions here. And then most recently in Portugal in 2019. Looking back at that, I was thinking to myself, did anybody have any idea that in just a few months after that meeting we were going to be in an international lockdown situation for a pandemic? I think not. So it's been a little bit of a gap now for this next meeting, but I'm really pleased that we're back together now and continuing on after that. So I looked at some of the topics that were brought up at those earlier meetings, and this is just a long list here, but certain things we will see continuing. We had some tutorials and education at that first meeting. That's obviously continued at this meeting, an opportunity to learn some things. Voice identification, talker ID, was a topic in 2005. There are papers on that at this meeting 20 years later. Enhancement of audio, being able to understand what might be uttered and things like that, is still of concern, and obviously authentication is still in there. At the 2008 meeting in Denver, the topic of electric network frequency analysis of recordings came up. And I don't know if we have any ENF topics at this particular conference, but that's still an area of interest, of course. And we started having papers about gunshot acoustics, and that, again, ended up being one of my professional interests from that time. Looking at other years, we had cognitive bias and issues that came up with subjective interpretation have been listed. We've had deep learning and artificial intelligence starting in Porto, and certainly at this meeting we can't avoid talking and understanding where we're headed in those things. So very interesting to kind of see these topics that seem to be continuous, and then those that are new and come together. And I want to, many of these people are here. I just looked at several names that popped out in those early meetings, and again, being an old guy, I'm kind of interested to see whose career is started at a meeting like this or continued, and there are several. And in particular, I do want to mention the first 2 names on here. So Roy Pritz, some of you may remember Roy. He was a professor at CU Denver and former president of AES, and he's the one who pretty much started the Audio Engineering Society's involvement in audio forensics. Roy sadly passed away suddenly, kind of after the first conference. So he was gone. And then Rich Sanders, his colleague here in Denver, many of you again may remember Rich, took over and chaired the second conference in 2008. And then sadly Rich passed away. So we've had those two individuals were very prominent and a big part of all of the things that we've done over the years, and we should remember them and thank them for their work. And again, each of you attending today, whether this is your first time or your 8th time at these meetings, thank you. You know, it matters professionally to have people who bring what they've learned and be good role models for everyone else as we continue. And several of the pictures out of those conference reports, again, several of the faces here I can see in the audience today. And I don't know that we're going to have a tour of the Porto port wine cellars on this visit or whatever. But anyway, a lot of very good things have happened over the years. All right, so that brings us to the third little segment of this topic, which is where we are today. And this is where I'm going to benefit if we have some time here, if people can add a few other things. But analog tape, is there anybody still finding analog tape? Or what are the circumstances that you have analog tape?
Usually post-conviction, when they go back and re-examine the past case.
Okay.
Yeah, legacy stuff, all NT type stuff.
Okay, so it sounds like for historical purposes, there may be a magnetic tape recording that is still relevant if there's a post-conviction review or some other thing like that.
Also for cold cases.
And cold cases. So if there's something that was investigated and has never been solved, going back to some of those things will be there.
Innocent projects, we get that a lot.
Yes.
And California passed resentencing hearings for attempted murder enhancements and from like the mid to late 90s, and there's bad contemporaneous like sound blaster conversions that oftentimes require going back to the tape.
Okay, so there may be, as mentioned, I don't know if everybody could hear, but there may be cases where there might have been a digitization of an analog recording that has been used, but then for evidentiary purposes, going back to that original magnetic tape may be important. And so now we get into other areas that AES is involved in with restoration and archiving of these. We have other conferences on that topic. But currently, I don't know. Maybe with all the interest in cassette tape, music and bootlegs and things like that, maybe there will be cases like that will come back. I think to me, probably the biggest change I've seen in the 20 years I've been involved in this is the increasing availability of these recordings. The introduction of flash memory has been a huge change in the way that we do business. It was often true that you had a magnetic tape and there was only so many minutes you could record on such a device, and so there was always a handling problem. And now with big flash memories, doing recordings of days or months at a time without stopping is kind of a casual thing for audio, and so that's been pretty remarkable. At least in the U.S., the vast majority of police jurisdictions now require or have a policy regarding body cameras or cameras in police vehicles and so forth. And so I think that increasing availability, at least in certain kinds of cases, is going to be something we see today. The other is the prevalence of user-generated recordings. And that term I mean is for people that are bystanders who pull out their phone and start making a video recording, or an electronic news gathering crew that happens to be on the scene or inadvertently picks something up. Or increasingly businesses and residences have surveillance systems, many of which now actually record audio in addition to video. And so increasingly in the cases I get, there's sort of a mishmash, so to speak, of these recordings that have turned up. And in the US, again, it's very common after an incident that involves something that occurred in public, that the law enforcement detectives will go around and poll every home and business in the neighborhood to see who might have made a recording of that incident. And so I think, again, today that's kind of routine for police work now, is to collect those user-generated recordings. Another topic that I think many examiners have kind of ignored is the fact that essentially all of the audio that we deal with from these body cameras and user-generated recordings has perceptual compression of some degree. So although we often act, or may want to act, like what we're examining in the audio is a waveform coder, meaning something that's trying to reconstruct exactly the pressure disturbance that was recorded, that is in fact not the case. What we're going to be reconstructing is a transformed version that's trying to make a rendition that a human being listening to it would not be able to distinguish the original recording from that recording. But often in audio forensic analysis, that's not what we're being asked to do. We're being asked to determine the timing between different events, or whether the utterance in this recording is by a particular suspect and things like that. So I want to caution everybody as you're working on this to be a little mindful of the issues that go into the format in which these recordings are made. The block timing of an MP3 recording, for instance, is not a casual thing. There's enough milliseconds in there that has a discrepancy on doing waveform analysis. So just be aware of that, and again, when you're talking about uncertainty of analysis, that's something that we need to deal with. In the U.S., Shot Spotter, the system from a company called Sound Thinking now, is often the case when we're dealing with gunshot sounds. For those of you who are not aware, Shot Spotter is a commercial product that is deployed in various jurisdictions around the country. Do we have that in Denver? No. Chicago, Washington, D.C., New York, some jurisdictions in Massachusetts. The idea is to have several microphones, many microphones that are deployed every 500 or 600 meters throughout a community, and each of the microphones has a computer system that's monitoring the sound, and if the computer software, the firmware, detects what it thinks is a gunshot based on some algorithmic parameters, that sensor will phone home, so to speak, to the central office and say, I heard a gunshot sound at this precise time. And the location of those microphones is known very accurately with GPS as well as the timing. And if the central office receives several of these contemporaneous reports from a certain region, then the ShotSpotter company says, well, that was probably a gunshot, and then a multilateration calculation is done to look at the relative time of arrival of that sound at the microphones, and then using the known location, mathematically you can make an estimate of where that sound came from. Okay. Now there are challenges in ShotSpotter because they have to first determine, is the sound a gunshot, or is it a firecracker or door slamming or who knows what. And then the second is the timing, because now the sound is propagating from whatever the sound source was, often not directly to the microphones, but diffracting around buildings, being carried by the wind, and so forth. So there's a lot of challenges there. Currently, ShotSpotter does use uncompressed audio, however, so the recordings that are made should be reasonably good for the purposes that they have. But that comes up quite a bit, and are some of you confronting ShotSpotter information in your work? Okay, so it's in jurisdictions where that occurs, it's often used. Another topic, and I think we'll have at least a paper or two on this at our conference, has to do with metadata. So now, not only do we have the recording of the audio, we might have contemporaneous video. So now we've got video and audio together. And then often we have metadata, or some kind of file header that's indicating information about the circumstances of the recording. And some of that is sometimes proprietary, other times it can be understood. And so that can help to look at the consistency question. One of the problems that we have now is with a very sophisticated adversary, it's possible for that adversary to construct forged audio and forged metadata. And so just the presence of metadata alone is not enough generally to say that that's accurate. It's only one piece of the puzzle that we have to deal with now. And then clearly we're right at the point in which machine learning and artificial intelligence tools are becoming available. And these have great promise to be very helpful to the work we do, but they're also fraught because now we have other concerns about the ability to understand what those algorithms are doing. When I testify in court, just trying to explain what a spectrogram is can be a challenge. And I'm a professor, and that's what I do for a living, but it's a little bit hard to get across to a judge or a jury of people off the street what we're talking about. Now, if we add on to that, trying to explain how an artificial intelligence algorithm has been trained and what is the nature of the training material and all that kind of thing, it's going to be an interesting era that we're going to get into. And inevitably we will. It's going to happen. It's happening now. Okay, so what challenges do we face? I've talked about a few of them here. One of them that's very prominent for me is this whole chain of custody issue with user-generated recordings. So the police collect these recordings from various sources. People voluntarily say, here's a recording that I made. Maybe one of the parties in the investigation produces some audio, like McKeever did. He made his own recording that he wanted to use later. So there's going to be a variety of challenges there, and I think we need to be mindful of that. And to the extent there are technological solutions that AES members can develop, that would be, I think, very helpful. We have ongoing issues with bias in audio forensic examinations, and this could kind of be its whole talk of its own, I think. But I'm bringing it up here as an example of one of the issues, especially for the new people who are getting into this field, that often many of us are eager to try to help out whoever the client was who hired us. So if there's a defense attorney who says, well, I want to show the following things, can you help me? Or there's a prosecutor that says, oh, I probably shouldn't tell you this, but we found these 4 shell casings at the scene, and this guy's a bad guy who did it, and so on. And now you're asked to analyze objectively the information. And so I think one of the concerns I have about our field is if we have a lot of people who are trying to make the case rather than trying to explain based solely on the audio forensic evidence what is known, we're going to be in trouble. So I recently was involved in a case where the other examiner had this kind of situation where the police found these different shell casings at the scene, and then immediately the examiner said, okay, well, here's the sounds, and which shell casings went with which sound. And of course, I advised the attorney, is there any evidence that those shell casings were part of this incident? They could have been dropped there a week earlier, who knows? So there's a whole bunch of things there that I caution all of us to be wary of. Often these cases are kind of interesting, and you want to hear, what the investigation was. It's intellectually fascinating, but I'm afraid that bias is something that we're going to have to be very concerned about, and how we make sure that the findings that we have are really reliable and important. I think the challenge of the rapid advances of machine learning and the tools that we have is going to be a challenge that we face, and I think meetings like this are a good place for us to start discussing how these things are done. The training bias, I think, in AI systems is an area of my concern, is what are we using to train the algorithms? If it's for speech, what range of talkers are we going to use? If it's for gunshot sounds, what is the nature of that evidence that we're going to use to make that training? The generative artificial intelligence, I think, already is starting to have some implications in our work. We have many times now where, let's say from Gaza or from the Ukraine or other war zones, there aren't really what you could say would be legitimate sources of information. It's typically coming perhaps from soldiers or from bystanders, or who knows who's generating these recordings. And very quickly, I think we're going to have the situation where trying to determine is this authentic or not is going to be very hard to do, because the generative AI that I'm starting to see, it's remarkably good. And again, for bias purposes, even if it's not authentic, seeing this or hearing it can have an effect on any investigation after that. It's hard to put it out of your mind if you've seen such a thing. And we still have, to some extent, although I think this is getting better, what I would call dubious methods that still come into investigations. And I use this kind of tongue-in-cheek proof by vigorous assertion testimony, which is, for instance, somebody saying, I can tell that's a .45 caliber gunshot just by listening to it. And I think any of us who have actually done real experiments involving gunshots understand that there are so many variables involved. The orientation of the firearm, the type of microphone, its position, the direct sound versus reflections, everything else, it makes that just really not true. But once an expert makes that testimony, again, it's very difficult for a jury to be told to ignore that. Because I think all of us, especially people who are not technically savvy, want to believe that there are people who can hear better than others and who can make these claims because they want to have that confidence. And I think from papers we've had at these conferences and other areas, that's just really not true. And we have to deal with it. So I'm going to want you to think about what other challenges do you see in your work or do you foresee? And I'm going to wrap up with a couple more slides, but I'd like you to think about that, and then maybe we'll have a minute or two here. Are we okay on time?
Yeah.
Okay, to have a little discussion about that. So I'm planting that seed that I'm going to ask you about here in just a minute. Okay, so here we get the soapbox time. And what is the call to action, or what in this keynote address, what is it that I would like to have you remember or have you think about throughout the next few days of this meeting? So I think the first thing I would do, and as a professional educator, of course I'm going to say education is vital, but I think it's very true. So helping to educate the participants in the criminal justice system or in other venues, I think is really important. So I don't think we have any trial judges here. Do we have any prosecutors or attorneys here? Okay, so we're all talking to ourselves, and that's great, but we need to, I think, figure out a way, and I'd be interested if some of you have ideas or maybe you've participated in such a things, how we help educate the criminal justice system about these topics. Because I think having judges who are knowledgeable about the nature of this type of evidence and so forth, I think can be helpful, because then hopefully, as at least in the U.S., as kind of the gatekeepers of what evidence is presented, they will be in a stronger position to make that determination. I think we, as in all of AES, want to welcome and encourage new researchers into this field. There are many topics that we're talking about here that not just 60-year-old white guys like me, and looking around some of you, are able to do. We need a diverse field of study involved here. So men, women, people of all ages, people who have come from different backgrounds, I think is very important. That's important for the success of our work and also for AES in general, is to have a welcoming and encouraging attitude that we can learn from anybody. It doesn't matter what your credential is necessarily, as long as you're willing to share and be involved. So I hope at this meeting and other places you will take a moment to welcome people who are new to the field and encourage their involvement. Many of you will remember, and I think Dante mentioned in his case, where he was interested and got support and encouragement. So let's all see if we can do that. I think it's important in our field not to oversell. And by that, kind of what I mean is losing sight of what the point of a lot of this work is. Not everything that's important in a court case or criminal case is measurable. Okay? Things like motive, passion, anger, attitude, recollection, a lot of these things are not really something that are going to be measured by forensic examiners. These are things that have to do with the social interaction of people. Similarly, there are things that we have that we would like to measure, or explain, which may not actually be important in interpreting the case. And so understanding that we need to stay in our lane of audio forensic analysis and keep that prominent, but understand that's only part of the larger picture of what's going on. So I think to the extent that we can remember as part of our education of those that we work with, where our expertise lies and the things that we can comment on, and then also the things that we're just not able to comment on or have a meaningful opinion about is going to be important. Another area that I've not heard talked about a lot, but especially when I'm thinking about law enforcement body camera devices, often I'm frustrated with their peculiarities. And I mentioned one of them, which was perceptual audio coding. So these devices generally have that because in the past, memory was very precious and you couldn't waste bits on audio. Well, now, with video recording and other things, recording straight PCM audio should not be a problem in these devices. There's plenty of memory in there. Okay? Or some kind of running a lossless compression algorithm should also be possible. So I think those kind of things would be important. A lot of my work with gunshot acoustics, often what ends up happening is that the recording is clipped or has other defects in it, and I have a paper tomorrow that I'll talk a little bit about that. But it would be nice if maybe there was a separate channel in the recording device that had a different gain setting. So now you have the ability to accommodate very large discrepancies in audio level for the different forensic purposes. I don't know how to have that conversation with the manufacturer of these devices, but I think that would be something useful. And we can go on with other examples like that I think would be a good call to action for all of us to have. It's very important to me personally, and I think to us professionally, that we follow the essential principles of ethics in the work that we do, and help our colleagues do this as well. It's easy to say, oh yes, I believe in ethics, and then you have to see what that means in practice. And often, again, that's not trying to give the answer that somebody's asking you to give. It's explaining what is possible and what is not possible, and staying with the things that you have, and also expressing the uncertainty that goes with those things. And I think long term, that call to action says we're in a professional status where we can be taken seriously because we're not trying to fake it and things like that. And for now, and then probably in the future, I think the call to action would be to proceed cautiously when we're dealing with these AI tools. The criminal investigations, particularly that we deal with, often have the potential to take people's rights away, to put them under supervision or in jail or something like that. The stakes are very, very high, and when we start talking in the U.S. about proof beyond a reasonable doubt, that's starting to be a question what that really means, and particularly now in the context of some of the tools that we're going to develop and that we use moving forward. So just, again, we're not going to not do it, but we need to proceed cautiously here and be aware of some of these concerns as we go along. Well, again, I really appreciate your willingness to sit here this morning and hear me speak, and a great joy and privilege to speak before this group. And it looks like, if my time is right here, we got 10 or 15 minutes. Is that true? So I wonder if there might be any comments or remarks here. Can I just take it?
Hello, testing. There we go. It's beautiful, thank you. I love it. I love being here. Thank you guys. I'm wondering about people's opinions from police officers, people involved in law enforcement here, who are allowed to fake evidence when they're interviewing people. Okay, they're allowed to literally lie to someone they're interviewing in an interview room. I don't know if you know that, in the US anyway. And they can say, oh no, we have DNA evidence that proves that you're at the event. We have DNA evidence that shows, so this is your voice, things like that, to get someone to then admit in an interview room. So I think AI is going to be, I'm picturing AI being used by the police in the future to clone a voice, right? To clone this bad guy's voice, to say, we have this recording of you, you know, or to clone one of his friends, right? And to play it back. Say, we got this recording of your friend, you know, admitting to it in the other room, or whatever. Or we got this conversation we recorded on a phone. So I'm wondering to hear you guys' thoughts about this, police officers or people involved in law enforcement, because that's allowed in the U.S., which is appalling to me, actually, as you can tell my tone. But I see it all the time with my work, with audio recordings, video recordings, where the police are allowed to completely fabricate to get a person to admit things.
Duran.
Thanks, great talk, great historical overview. I was just going to mention that the Watergate report, I think, is still on the AES website. It should be required reading. You have to dig a little bit for it. And it also, 2 points about that was the amount of money that the government put into that research. They hired Bolt, Baranek, and Newman, and all those individuals you see there, and they had unlimited resources. So some of the first analog to digital, digital to analog, AD conversions were done for spectrographic analysis, and spectral analysis, I think, is one of the interesting things about that report. The other thing I wanted to mention historically was 2009, the National Research Council put out a very important document called Strengthening the Forensic Sciences. And one of the principal points of that was, as we talk about whether or not what we're doing is scientific or not, is not only the ability to repeat something, right, and come up with more or less the same result, but also be able to talk about error rate. And so, you know, it's the difference between specificity and, you know, and the ability to eliminate a false alarm. So to your point there at the end about the stakes being high, that's where the, you know, saying something is true when it's not, a false alarm, has incredible implications. And often in forensic reports and whatever, people don't address just, you know, the error rate that can occur with something. And so this report, 2009, that's available online, free, everybody should read it, Strengthening the Forensic Sciences from the National Research Council. It goes over all of these issues for things like bite analysis, hair fiber analysis, etc. And, you know, the history of audio forensics, of course, is highly tied to things like lie detectors, you know, devices that can do magic things, and other things like that. So you can look at that holistically. Final challenge I'll comment is that I think we need to be thinking about experts in other fields and how we collaborate with them. Because the science of artificial intelligence, for instance, and voice synthesis and speech, etc. At the London conference, we had a number of experts who worked specifically in phonetics, speech, and their expertise far exceeded what your typical audio forensic person has because they're studying this. And the same I would say about computer forensics or video or anything. So we need to be collaborative, I think, is a challenge. So.
Yeah, terrific. Both these comments, I appreciate it. Yeah.
I'd like to follow up from the first comment we made in this question and comment section. Does anybody know if law enforcement agents are allowed to lie to gain?
Yes,
all the time.
Yes, they are allowed to lie. They do admit to it, and we can make this go away. Just you're not in trouble. I'm going to help you. There's lots of lies every day.
I had a case where the DNA, they said we have DNA evidence of your foot in the car or your hair, and they didn't. They produced a document that showed it to me. I'm just giving you one example.
How is that not illegal?
Well, I'm not an attorney, but I think this points to the right to remain silent. Maybe the attitude you want to have is not get into that kind of conversation with law enforcement. Is wait till your attorney's there. So.
But it is obviously different from country to country.
Correct.
In my country, it's not allowed at all.
Yeah, no, the UK.
No, we should all. Yeah.
Eddie, in Denmark, is there not allowed?
Like Norway.
Yeah. Okay. Yeah, Keith.
On the topic of recording and formats, when recorder manufacturers talk to us about what they should be doing to get not to move away from conceptual and tracking, we're recommending everybody move to a floating point format.
Yeah.
Whether it's 32-bit floating point, or if you don't have that many bits, record it at least in what's called a block floating point format, which for everybody else is just like scientific notation, and this is an exponent. And it makes all your front-end gain problem goes away, and gives you whatever number of bits you've got to record with, it gives you the best results.
Hey, Rob, I'm interested in your take on the topic of this, and kind of combines the, I guess, specific tools and law enforcement, and then also taken from other forensic disciplines. And actually, there was a podcast episode I was listening to the other day with a guy named Patrick Geller, someone that's known from AES 8th. But he was on the topic of tools that are available only to law enforcement and not to the private sector. So, what are your thoughts on that?
I'm not sure specifically what that would be.
Well, I guess as far as like perhaps bias, but also maybe an unfair advantage, or perhaps even a tool that says law enforcement, like you cannot be an expert using this tool unless you take our training, but you are not law enforcement, therefore you may not take the training, and therefore any of our deductions that might have come from this analysis, you are not an expert in and you cannot speak against.
Yeah, that's very interesting. I think one of the realizations I had, 20 years ago when I first got a call from an attorney asking about something was sort of the nature of in the U.S. anyway, of the adversarial justice system. And so very quickly in a typical case, both sides hire experts who then often are required to duel with each other. So one example would be transcription. So there will be a noisy recording, which is very difficult to understand what's going on, and one expert will come up with a transcription of what's being uttered in that recording. Often that includes choices of words that are pretty much unintelligible. They assign a word to that. Then the other side now hires somebody who says, no, they didn't say that. They didn't say, I did to do it. They said, I didn't do it, in this little snippet of 300 milliseconds. And now what is the jury supposed to do with that information? So, we've got this kind of thing. So I'm imagining in cases like this, you're going to have the prosecutor, probably in this case, putting forward this evidence that there's no way for the defense to refute it or argue with it because of this sort of a technical prohibition. So I don't know, again, not being an attorney, I don't know how the courts are going to react to that kind of thing. We have a few cases, not in audio forensics, that have come up with position determination from mobile phones, for instance. So there will be a jurisdiction that uses some algorithm to figure out where a mobile phone was at a particular time using radio frequency timing of the signal arriving at the cell phone towers. Sort of a multilateration, but using RF instead. And again, often this is something that's produced in this technical means that there's no way to determine did they do it right or anything like that. So I think this will be a challenge, not so much for our technical work, but how are the courts going to interpret this? So very interesting.
And possibly kind of an educational standpoint of how well does the judge perhaps understand this stuff, and how perceptive are they to an education from the experts perhaps in this room. So.
Well, certainly the 2009 National Research Council report that Durand has mentioned is along those lines, is ultimately the gatekeeper in the U.S. anyway of what gets in is the judge. And the judge then, if they aren't really aware or want to be aware of these things, it's going to be a problem. So there's an interesting realm there of how these things will be determined. Yes, sir.
To one of your first points, you said that we needed to be better to lecture the judges, the prosecutors, and so on. think this is very important. To use both time and energy to tell them what is possible and what's not possible, but also to teach them how to listen. In a lot of cases when I do the audio recording, it's a nice timeline for an event. And in the recording there are some elements that are scientifically provable. This is this sound. But there are also a lot of events that are not scientific and provable. I hear a guy walking down a stair. It's very difficult to prove that scientifically. But my brain, based on millions of years of training, says to me, this is what you hear, actually. And for us to be able to deliver a speech in court, and also to put in what we need to get the court to listen and not say, this is what make it open. This is what you hear, be aware of what's happening here.
Mm-hmm.
And if we are in any luck, they will hear the same as us, in a way.
Mm-hmm.
I think that's important. And my last comment goes to the bias thing. You briefly mentioned it, but you focused on what we are asked to do. I find it's very dependent of the material. Because if I hear a vulnerable person, a child, I get the bias without being asked to do something. And I can't turn off the audio. I have to listen. Even if you watch on a video with bad material, you can choose to watch up on the left screen. We can't do that. We have to listen to the whole shit. So we have to be aware of and being trained and also taken care of so we can deliver our reports with as little bias as possible. Thank you.
Yeah, thank you.
Yes. And that's time, everybody, so thank you.
Yep, thanks.
Thanks, Rob.